Dumelani sanibonani ninjani molweni avuxeni thobela. Today we have Department of Private Law of Damage, LPL 4802. It's due in 2 days, and today I have solution for you. Now let's start here. We have a scenario for someone who live in Engutu, and then they're talking about the neighbors. Then there was a veld fire, and then that veld fire resulted in a loss. And then there was someone who's suing. This one. I believe you have read the scenario. I don't want to be more into the scenario. Now, we go back, we go down to the background. They are talking about the concept of wrongfulness and negligence. And then they said that they are often confused, yet they play distinct different roles in South African dialect law. And then we have the case, this one of Mahlangu versus Mahlangu. And then a lot has happened here. They said a lot. Now, we go to the question. They said, provide a clear description of how South African court will analyze the claims and defenses in Mahlangu v. Ngubanes through legal concept of wrongfulness and negligence. Remember, we are analyzing through the concept of wrongfulness and negligence. In doing so, distinguish between the two concepts and discuss how they are assessed independently. Furthermore, with reference to relevant legal authority, determine whether liability is likely to be imposed and on what basis. In your answer, you must refer to at least 5 specific cases. They even mentioned some cases here to make things to elevate things. Now, they say that you must not exceed 7 pages, which is, if you are writing a real assignment, you'll be writing like 4 pages. You can't write like 7 pages. It will be like 4 or 3 pages if you are answering them correctly. Now, where do we start? Where do we start is a very good. Now, this is where you start. We start here in the Law of Dialect, 8th edition, Nithling Port that that's where we start things. Then you don't just waste your time. You just come to the fault. Then on the fault you come down, and then you find the distinction. These are the distinction between wrongfulness and negligence. You start here. Then they are given number A in the wrongfulness, the reasonable person of the defendant's conduct determined by weighing a conflict interest. And then when we go down here, they even give the case of MTO Forest, and then they said something you could come read during your own time. And then number B, they say wrongfulness is consent, and then they contrast it with negligent, and then they go to number C. Those all were given the distinction, just like the way it is number D here and number E here. And then I think that one was last. Then now you know the distinction between those two. Now we go to where next now. Now, don't forget that negligence is based on foreseeability and preventability. Now, they are here. You can come and read during your own time to understand about, or else you will just do yourself a favor and you get this document, which I'm going to open, and then you understand. Now, when we assess it independently on the wrongfulness, you must know that we have a traditional approach and a new approach, right? And the traditional approach to determine wrongfulness emanated from the decision of Minister Van Police, where it was held that in order for conduct to be deemed wrongful, the harm suffered must be caused in legal, reprehensibly, and unreasonably manner, contra bonus more, in light of all surrounding. And then they said a lot of things. In determining wrongfulness, the basic question is whether legal recognized interest was infringed, and if so, whether it was infringed in a legal, reprehensible, or unreasonable manner. That's how the test, right? Now, we also have an idea about the recent approach is stemming from telemetrics, right? And then, according to these cases, that wrongfulness is present when, according to the policy considerations or public policy, it will be reasonable to hold a person liable, or that wrongfulness turns on the reasonableness of imposing liability for the conduct. Now, when you move on, you just need this document. And don't forget to come here and read about the Wildfire Management and Legal Liability in Rural South Africa, a comprehensive analysis. It will give you the go ahead about FPA, you know, and then the role of the FPS, they are saying. Then after that, you will find about the legal principle of negligence in the context. Then they've talked about the section, that one of the Constitution, I mean, the National Veld and Forest Fire Act, that one section, they've talked about it and how is it, the cases that are there, they talk about it, the case of this one, the case of this one, the relevant South African law, some of the sections that are relevant, they are mentioned. So it's good that you pass by here reading, right? You pass by here reading so that you understand about it and then liability and so on. So let's move on to another document which is important. Now, this document is one of the best documents that you will need. This one, you need it because it's talking about the fire. A strong wind caused the fire to spread into Whittle's Boss, where it burned for several days and destroyed hectares. The appellant suffered considerable loss. It's the similar to that one that you have been given. Now, in this article, you will learn about wrongfulness and fault. They have described what is wrongfulness in this one. There's a good document about the wrongfulness and fault. Remember, fault is negligent. Now, this guy was making the criterion of wrongfulness. In this case, you can see here the criterion for wrongfulness, in his view, is the reasonableness of holding the defendant liable. And then they talk about then negligent omission is only if it occurs in circumstances that the law regards as sufficient to give rise to a legal duty to avoid negligent causing harm. It's a nice document. And then you will also come and read about the foreseeability and preventability of a harm are relevant for determination of both wrongfulness and negligence, so that a degree of confliction of these two elements is inevitable, and that if a degree of overlap can be accepted without negating the distinctive functions of wrongfulness and negligence as separate elements of a delict, it will not be a bad thing. Nathan, based on his observation that certain factors are relevant to both wrongfulness and negligence on a number of decisions of the Supreme Court of Appeal. Nevertheless, Nathan emphasized throughout that where it is appropriate, a certain extent of overlap should be accepted, provided that this can be done without negating the distinctive functions of wrongfulness and negligence as a separate elements of delict. In the case of wrongfulness, to indicate that a legal protected interest has been infringed in unreasonable manner, and in that case of negligence, to indicate the blameworthiness of the alleged wrongdoer for such infringement are not violated. To deny this reality would amount to placing the various factors relevant to establishment of wrongfulness on the other hand, and negligence on the other, into watertight compartments where no particular factor may be applied with regard to more than one of these elements. There's a lot that is said there. I was just reading those ones because they're important. Now, I said that this document is big. Now, you come and read about wrongfulness and foreseeability. Remember, foreseeability is part of the negligent. Then you will come and read about those wrongfulness and foreseeability. What are they saying in this circumstance? And they say the defendant conduct is determined diagnostically ex post factor by taking into account all the relevant facts and circumstances that are actually present. And then we come to negligence and preventability. Remember, in your even though I've already talked about that other one, even here in this document, they have talked about the National Veld and Forest Fire Act, which is section 34.1. They also talk about section 34.2. So here is a nice thing to be, right? And then you come and read about that National Veld and Forest Fire. Remember in your assignment, they said that you must also include national veld and forest fire, right? When they finish, sorry, at the end they said it should be emphasized that the fact that a person acted wrongful does not necessarily mean that he will be intellectual liable, as negligence still has to be established. And then it was explained later, an omission is unreasonable and this wrongful where, according to the Bonnie-Morse test, a legal duty rested on the defendant to act positive in order to prevent harm, and he neglected to comply with such a duty. However, where defendant did attempt to comply with such a duty, in his attempt coincided with what the reasonable person would have done. His wrongful act is not accompanied by negligent conduct. They give example by Minister Pisas Lamba, who may be cited as an example. Fire broke out on X land without any fault on his part. Despite his attempts to extinguish the fire, it spread to Wise land and caused damage. Remember the case of Minister of a Forest, Pisas Lamba. It has been mentioned here, so it is good that it has been summarized. Where is that case? Oh, I thought this case it was here. Kusamba. Oh, no, it's not mentioned here. No, I read somewhere where they were mentioning. Oh, I'm making mistake. No, it's not here. However, I thought that the question they were cited there. Anyway, let's move forward. You must include this case. Is very very much important. So when you go to write, now you know how to write that one. Including this case, don't forget of the Kuthlamba. It's a very very crucial case. Now you know how to write. So when you answer, you must show that the dispute in Mashangu, Fisas Ngubane, raises fundamental questions about the distinction between wrongfulness and negligence in South African delict law. Mr. Mashangu seeks patrimonial damages after a veld fire originating on Ms. Ngubane's farm spread into his timber plantation, causing significant loss. The court must assess whether Mr. Ngubane's omission to prevent the fire spread constitute wrongfulness and negligent conduct, and whether liability should be imposed. Wrongfulness is not about the defendant's blameworthiness, but about whether the conduct itself is illegal, reprehensible, in light of the Bonnie-Morse and legal convictions of the community, constitutionally understood, as Nugent J.A. explained in Minister Security Visas. This is the case. An omission is wrongful only if the circumstances justify the imposition of legal duty to prevent harm. And I give the para. The court stressed that recognition such as duty requires balancing competing social and policy considerations, not intuition. In Loriora Mvula Quality, which is another case, Jay clarified that inquiry into wrongfulness is normative, focusing on whether conduct is acceptable within society, constitutional, and policy framework. Now, similarly, in the case of fatal assessment, the Constitutional Court emphasized that wrongfulness is grounded in a policy, reasonable, and constitutional norm. Applied here in the question is whether Ngubane's failure to prevent the fire spread amounts to unreasonable infringement of Mahlangu's property rights. Section 34 of the National Veld Forest Fire establishes a presumption of negligence where damage is caused by fire spreading from land under a defendant's control, unless they can show reasonable compliance with statutory duties, as seen in MTO Forest. However, wrongfulness does not impose an absolute duty on the landowner to prevent all fires from escaping their land. The duty is one of the reasonableness, no strict liability. On the effects, Ngubane maintained fire breaks, joined the local fire protection association, and responded swiftly. This measure suggests their conduct was not contra bono mors. Imposing liability despite their compliance would arguably extend wrongfulness too far, placing an undue burden on smallholder farmers. Negligence, by contrast, is about the blameworth of the defendant. The test established in Kruger v. Kotzi ask whether a reasonable person in the defendant's position will have foreseen the reasonable possibility of harm and taken steps to prevent it, and whether the defendant failed to act accordingly. Unlike wrongfulness, negligence is charged prognostically, ex ante, considering what the reasonable person would have known at the time. In velvet cases, negligence has been tied closely to statutory duties. In Gouda, the court held that the statutory presumption of negligence applies only where the fire qualifies as a wildfire under the Act. And then we also has another case clarified that both landowner and occupiers bear statutory obligations to take fire precautions. Furthermore, in the case 10.1, the court held landowner liability for failing to oversee negligent fire use by other on the property. In Mahlangu versus Ngubane, the key negligence inquiries whether Ngubane took the precautions expected of a reasonable farmer in the prevailing conditions. Expert testimony confirmed that the fire would have breached any standard fire break given the wind, Ngubane's compliance with statutory obligations, fire control, and FPS membership will likely suffice to rebut the presumption of negligence under Section 34. Remember, I started Section 34 of the Velvet Fire. Their conduct compares favorably with the reasonable standard set. So this is how you are likely to be answering, right? And then in applying this principle, Ngubane's omission may initially appear wrongful since landowner bear a legal duty to control fire. However, a compliance with statutory duties and best practice renders the imposition of liability unreasonable under the Bonnie-Morse test. Furthermore, negligence is not established because she acted as a reasonable landowner would in these circumstances, and expect evidence suggests the fire spread was unavoidable. And then I give by the last case of the Kwathmala. That's how you must write, right? Okay, guys, I've given you all the hint. I know that now you know. Good luck with writing damage. Have a nice day.